Hello, my name is Damien Geradin, and I'm delighted to participate in this virtual session of the OECD. I would like to talk about digital markets, and in particular, I would like to focus on what has become an important initiative of the European Commission in recent months, which is their work on what could become an ex-ante regulation of digital platforms. So as you know, the European Commission has been at the forefront of preventing abusive behavior by large digital platforms. You know, of course, that the European Commission has adopted three major decisions against Google, the shopping decision, the Android decision, and also a decision about advertising. And it has imposed very large fines. The Commission is also investigating other platforms. It is, for example, looking at Amazon. It is also looking at Apple for other types of abusive behavior. Now, there is a feeling in Brussels that competition rules may not always be the best solution to deal with abusive conduct from platforms. And there are several reasons for that. I think one reason is that competition law investigations tend to be very specific. They will only focus on one set of facts. For example, the shopping decision of the Commission focused on comparison shopping services, and although many other verticals suffered from the same problems as comparison shopping services, the decision doesn't really do anything for them, although it can be used as a precedent. The second thing is that competition law investigations tend to be very long. These Google investigations took many years, and of course, digital markets can tip fairly quickly. So by the time the decision is adopted and remedies are imposed, well, some of the main competitors may have left the market, and therefore it becomes extremely difficult to restore competition. And then the third reason is that it is difficult for competition authorities to adopt well-functioning remedies. You can impose structural remedies. Some have called for platforms to be broken up, but this is a very big step, of course, and also you may lose some efficiencies that are linked to integration. And then the alternative is to adopt behavioral remedies, but they're not always functioning, and also they may require monitoring. So based on these findings, the European Commission has been exploring another approach, which would be to adopt a set of rules that would apply only to a limited number of platforms, which are generally referred to as digital gatekeepers or systemic platforms, and which would basically contain a set of principles or perhaps obligations that these platforms would have to comply with. That's why it is often referred to as ex-ante regulation. So the idea would be really to have these principles or requirements adopted, and they would apply independently of whether there is wrongdoing. The Commission would not have to necessarily to open proceedings, but of course this idea of an ex-ante regulation is something quite new, and it raises a number of questions that I would briefly like to talk about. I mean, of course, the first question is there a need for this regulation? And I mean, of course, depending on your viewpoint, you may say, well, there is no need to do that. Competition rules can be sufficient, and that is the view of the platforms, I suppose, as well as those that are fearful about regulation. But another viewpoint is that indeed there is a need to complement competition rules for the reasons that I've mentioned a moment ago. So I think there's a fairly broad consensus at this stage that these ex ante rules are needed. I really believe that there will be an ex ante regulation. The Commission has mentioned it many times. The Commission has recently commissioned a study in order to examine how these ex ante regulations could be set up. So I think that there is, I think I can say with a fairly high degree of confidence that the Commission mind is really made. The second point is to ask, but to whom should these ex ante rules apply? That's, of course, a significant question because I think generally the Commission has opted for a purely symmetrical approach, whereby, for example, the platform to business regulation, which already imposes a certain number of transparency principles to platforms, applies to all the platforms. Actually, all the platforms that fall, of course, within the scope of that regulation. GDPR, which deals with data privacy, applies to a wide range of companies. In this case, I think the approach would be more like the approach that the European Commission has adopted with respect to telecoms regulation. In other words, it would focus on a fairly limited set of companies that would meet certain criteria. The question is, what should the criteria be? And I think you can look at two types of criteria. You can have qualitative criteria, which would be to say, well, we're looking at platforms that are digital gatekeepers because they control access to a wide number of consumers. They benefit from network effects. They have a lot of data. I mean, you can come up with multiple criteria, but you can also have more quantitative criteria, which would be to look at the amount of time that users spend on these platforms. You could look at their resources, and so on and so forth. And it seems that the Commission would likely go for a combination of qualitative and quantitative criteria. I also believe that when we think about digital gatekeepers to which these rules would apply, we would speak about a fairly small subset of companies, probably less than 10. But of course, nothing has been decided. The second thing that would have to be decided, besides to whom should the rules apply, is what should be these rules? And there, I think that the rules would probably deal with the sort of problems that have been generally complained about when it comes to online platforms. I mean, you could have rules, for example, about self-preferencing, which is a fairly significant problem for many companies that compete with platforms. You could have rules about data. For example, the criticism that is often made to Google and Facebook is that they tend to combine all the data they get from a variety of services, from Android to Maps to search, and use this data, for example, to conquer new markets. Well, you may wish to put some limits to that. There could be also rules designed to prevent some forms of exploitative practices, and so on and so forth. You could have rules also about interoperability, which in some cases may be lacking. The goal of these rules would be to maintain contestability on digital markets. Once again, there is a question as to whether this ex ante regulation would contained very specific rules or broader principles, I think the jury's still out. But certainly these rules of principles will address the traditional problems that are mentioned when it comes to digital gatekeepers. I think the third problem would be how do you enforce these rules? Do you want to use DG competition to enforce these rules, or would you like to create a new EU platform regulator, or would you like maybe to have enforcement done at the national level, but then by which regulator? As you know, the European Union operates at two levels. You have, of course, the EU level with the EU institutions, but then a lot of legislation, directives are actually implemented and enforced by national authorities. So what would be most efficient? Well, I think that perhaps for the designation of the platforms, it would be better to have this done at the EU level. As to enforcement, you could have what you already have for competition law, that is to have enforcement both at the EU level, perhaps for the cases of that have community interest, and then have some national enforcement when the problems are more localized. Again, I think this is an open question. My impression is that soon in the European Union, competition rules will be complemented by ex-ante regulation, as it is the case in other sectors, as it is the case, for example, in the energy sectors, in the telecom sectors, in the transport sectors. Well, then you may have also some sector-specific regulation when it comes to platforms. I emphasize the word complement because I don't think that the intention of the Commission is to shift all investigations and disputes to these new rules. Competition law has a very important role to play, and therefore what these rules would do would be to complement possible gaps rather than compete or let alone replace competition rules and competition authorities. To end this short presentation, I think that there are also discussions about how to improve the effectiveness of competition rules, EU competition rules and EU procedures. I think there's a bit of pressure on the Commission to do something about it because indeed investigations tend to be slow. There are good reasons for investigations to be slow, such as, of course, to gather the evidence and analyze it very precisely. Also, you have to comply with due process, ensure that rights of defense are respected, but still, in some cases, it seems that the length of investigations got out of control. So perhaps we need, or the EU needs to make some improvements there. Recently, I've heard also of the possibility that would be given to the European Commission to initiate market studies, such as is the case in the United Kingdom, where the CMA can do market studies. The Commission can already do sectoral studies, but unlike market studies in the UK, it cannot adopt remedies when it believes that the market is not functioning well. If a sectoral study, a sector inquiry, actually, that's the real word. If a sector inquiry suggests that there is competition problems, then it will be for DG Comp to open proceedings and start some investigations. In the UK, they don't need to do that. Of course, once they have gathered the evidence and found evidence that the market is not functioning well, they can adopt their own remedies without investigating any particular company. So thank you very much for your attention. I will stop here.